You stop the question whenever you feel your time is over, right? That you have to go off somewhere. So we'll leave it to you to decide when is it that you'd like to take a break, and there'll be a set of questions, simple questions, all will relate to the topic, the issue of basically law and economics. Okay, well, let me introduce you. I'm glad to say that Mr. Bibek Debroy is now with us. As you all know, he is the chairman of the PM's Economic Advisory Council. And before that, he was a member of the NITI Aayog from 2015 to 2019. Bibek is a very, what else, there's no point in my going on and on about his taught all over the place. I think one of his most important contributions were earlier when you were director of the Project Large, Legal Adjustment Reforms for Global Economy, where they spent many years sort of working out how you have to change your legal structure in order to correspond to changing international scenario. He's worked in Ministry of Finance, he's Secretary General PhD Chamber. There also he has taught in various places, Presidency College, Calcutta, Gokhale Institute of Political Economics. He was very nice to teach part of a course when I was chairman of the Center of Economics in JNU, where he taught a course, part of the course in law and economics. Also, of course, as you know, he was a former teacher of the IIFT and the NCAER. Let me end by saying he's a multifaceted character, and he's actually quite a scholar in Sanskrit. And in fact, there's a lot of stuff. He's written a lot of books. He's translated the unabridged version of the Mahabharata. Also, as far as I remember, the Haramans, the Veds, Valmiki Ramayana, Bhagavad Gita, among many books that he has translated from Sanskrit into English. And I must end with the last one, that he has featured in the 2019 Limca Book of Records as the most prolific translator. The last part, of course, was new to me. The rest of it I knew. Bibek is also a personal friend. We've been friends for many, many years. I would say now more than a decade, more than 2 decades, I would say. We've been friends. And I have a great respect for him as an economist, and particularly as one who's understood the interface between law and economics, which unfortunately economists have not understood and lawyers have not understood. And it's now that both classes of people are now understanding that they cannot do economics without knowing law, and you cannot do law without knowing economics, the way the world is going forward. So without wasting any more time, Vivek, over to you. So say about 40 minutes of lecture, and then we'll have a little bit question answer session from students. And whenever you want to put a stop because of time, just say so, right? Okay, Bibek, over to you. Over to you.
Thank you, Manoj. Thank you for inviting me to deliver this talk on law and economics, which is a very, very vast area. So there is only limited ground that I can cover. Manoj, of course, is a dear friend. He did the opposite of exaggeration in the sense that we have not known each other for 2 decades. We have known each other since about since the mid 1970s, although we are very reluctant to admit that publicly. And as Manoj also said, we are reluctant to admit that publicly because it reveals our ages, nothing else. As Manoj also said, and as some of the students in IIFT might know, I had the fortune of teaching in IIFT as a professor for pretty close to 8 years. As I said, the law and economics area is a very, very broad area. So let me start with a few anecdotes to motivate your thinking. Manoj said that I headed a project on law reforms known as LARGE, which was started towards the end of 1993 by the then Finance Minister, Dr. Manmohan Singh. It was a Finance Ministry oblique UNDP project, and it was started with the objective of ensuring law reforms and legal reforms. There is a curious anecdote about how this project was started in the first place. There was a famous professor of economics, I shan't name him. In the year 1993, he was scheduled to go to Paris on a UGC-funded conference. And at that time, the per diem for visiting abroad was 65 US dollars. Most economists know each other, so therefore he dashed off a letter to the finance minister, Dr. Manmohan Singh, saying that look, $65 is too little as a per diem. Can you possibly enhance it? So a file was started in finance ministry. A, why should there be special discretion towards one particular individual? If we are going to remove this ceiling and enhance it, why should we do it for only one individual? Why not do it for everyone? B, what particular clause determines this threshold? Which rule leads to this ceiling? Which, of course, took one to the now defunct Foreign Exchange Regulation Act of FERA of 1973. So if we are going to change that particular schedule, why not look at all of FERA? If we are going to look at FERA, why not look at all economic legislation? And that is how this project known as Project Large was started. I mentioned this anecdote to illustrate the point that unfortunately, attitudes towards legal reforms have often been very ad hoc. Oh, we are going to join the WTO. So we are members of GATT, but nonetheless, after the Uruguay round agreements, there are certain commitments that we have to the old GATT and the new WTO, perhaps in the form of intellectual property rights. So let us look at the laws that concern intellectual property. Alternatively, we are opening up the financial sector, or we are opening up the infrastructure sector. So therefore, we need to scrap the historic legislation that led to monopolies in the financial sector, for civil aviation, for power, other infrastructure areas. So therefore, we look at law reform piecemeal. The second anecdote I want to mention, well, before that, I already said, let me clearly now state. So when I exited IIFT, when I left IIFT as a professor, it was to head this project on law reforms. After this, I met a very interesting gentleman, and this gentleman's name was Lal Bihari. Lal Bihari was alive, but he had been declared dead by his maternal uncle, who coveted the piece of land that he had. And Lal Bihari fought for years and years to establish that he was actually dead, not alive. I will not say more about Lal Bihari, because there is a film that's been made on Lal Bihari which you can watch. It's called Kagas. But there are many such Lal Biharis around. When I started this law reforms project, I discovered that there was an entry in the Guinness Book of World Records which said that the longest standing case in India lasted for 761 years. It was started in 1205, ended in 1964. So therefore, India had the dubious distinction of the longest standing case ever in recorded history. That entry in the Guinness Book of World Records was incorrect, but nonetheless it illustrates the point. So we are familiar with statements like Sunny Deol in Damini, Tariq pe Tariq, Tariq pe Tariq. All of us willy-nilly interact with the legal system almost on a continuous basis. So we are particularly concerned, or should be concerned, with the fact that the dispute resolution system is not efficient enough. Which brings me to the fundamental question. As students in IIFT, you will have been taught about markets. You will have been told that the reforms are designed to ensure a greater reliance on markets. What is a market? A market is not the shop in Katwaria Sarai that you turn up in to buy your daily groceries. Yes, it is a market, but that's not the sense in which economists use the word market. Economists use the word market in the conceptual sense of a place where buyers and sellers congregate to transact goods and services. So that is a conceptual notion. However, all markets function in a certain institutional setting. Markets are context specific. Markets are society specific. And underpinning the framework of that market for any given society, for any given economy, is set by the law. So the legal system is part of what may be called infrastructure. And if that infrastructure does not function efficiently, then obviously we will not get the requisite rates of GDP growth. So if you look at attempts, cross-country attempts to measure how the Indian legal structure functions, whether it is by the World Bank or someone else, admittedly such cross-country measures of law and legal systems are very difficult to quantify and measure, particularly because in a country like India, traditionally, we have belonged to the strand that is known as the common law system, where everything is not codified, unlike other legal jurisdictions which are part of the civil law system where everything is codified. So admittedly, such cross-country work on legal jurisdictions is very difficult to pin down, quantify, and measure. Nonetheless, if you look at these, you will find that the Indian legal system does not function very efficiently. So therefore, as part of that infrastructure, the Indian legal system should deliver better. It should be more efficient. This is regardless of the reforms post 1991. Even if the reforms post 1991 had not occurred, it would have been important to reform the legal system. But certainly with the reliance on the market, certainly with the post-91 reforms, that emphasis is accentuated because you do not want the legal system to hold up growth. What do I mean by the legal system? The framework for all of our laws now in post-independent India and certainly post-1950, since the adoption of the Constitution, is the Constitution. So that the Constitution sets out the framework for the entire legal system. So if one is going to understand the legal system as students, one of the first things you should be familiar with, even if you do not become full-fledged lawyers, is the Constitution. We loosely use the word law. The word law means different things. At a certain level, it means a statute. So at one level, law means a statute. Under the Constitution, we still have laws that go back to pre-1947, but that apart, under the Constitution, a law can be enacted either by Parliament or by the State Assembly, depending on where that item features in the 7th schedule, whether it is in of the Constitution, whether it is in the Union list, whether it is in the state list, or whether it is in the concurrent list. So if by law I mean statutory law, then pre-independence apart, we are talking about laws passed by union government or laws passed by state governments. You will have heard the maxim, everyone has heard the maxim, ignorance of the law is no excuse. So as a citizen, I need to know what the law of the country is, and at the moment when I'm using the word law, I'm using the word law only in that statutory sense. So first question before you, as a citizen, do I have access to all the statutes that have been enacted? So that's a first level question. Since ignorance of the law is no excuse, as a citizen, do I have access to every statute that has been enacted because I'm supposed to obey the law? The answer is no, you don't know. For the union government, there is something called India Code, which tells you what all the statutes are. Do I know what all the statutes are for state governments? Not yet. Now, don't get me wrong. Since you study in Delhi, if the question is, do I know all the statutes? Do I know all the statutes that pertain to the state of Delhi? The answer is not yet. We will get there eventually. I may know the major statutes, but I'm not talking about the major statutes. I'm talking about all the statutes, not just the major ones. So whether it is Delhi, whether it is UP, whether it is Haryana, whether it is some other state, I will certainly know all the major statutes, but I will not know all of them. Minor question, nonetheless a question of that information being available in physical form and increasingly in digital form. Once I have a statute, one question to ask is, many statutes have been enacted at various points in time. So some of these statutes may be very old. Do I need that statute? Old statutes also exist in other countries. In London, taxis in London are still governed by the Hackney Carriages Act. Hackneys were the old horse-drawn carriages. And since Taxis are still governed by the Hackney Carriages Act. In London, taxis are legally required to carry bundles of hay for horses. So old laws exist in other parts of the world also. In Boston, for example, the law specifies what will be the width of a belt with which a husband can beat his wife. So old laws also exist in other countries. The point, of course, is that in other countries, these old laws are not necessarily used to harass people. In India, sometimes these old laws are used to harass citizens. For example, until recently, we used to have something known as the Indian Sarais Act, which goes back to the second half of the 19th century. It has now been repealed, but until recently we had that. What was Sarais? Sarais were those roadside places where water was offered, wells. Under the law, under the Indian Sarais Act, Sarai keepers were legally required to offer free glasses of water to passers-by. So there was an actual instance where the Sarais Act was invoked against a 5-star hotel in Delhi because that hotel was not offering free glasses of water to passers-by. So the point here being, and this is a minor point, nonetheless it should be mentioned, that these old laws can be used for harassment, so we need to repeal them. As people who live in Delhi, you should be aware that in Delhi, even today, there is a law that requires every able-bodied citizen of a certain age group, you included, to go out and help the government in fighting off invasions of locusts. Invasions of locusts will be announced through the beating of drums by the district magistrate, and when you hear those drums beating, you have to go out and fight those locusts. So first part, get rid of the old laws. Since this government, the union government, came to power in 2014, through a succession of acts, around 1600 such old laws have been repealed. But the comparable exercise has not yet been done in the states, because remember I said statutes can be union government or they can be state government level. Systematically, old laws have not been eliminated in all states. The only 2 states where there has been a systematic attempt to eliminate old laws and do other aspects of law reform, statutory law reform, are Kerala and Rajasthan, not any of the others. When I'm talking about old laws, do realize that rare is it the case when I will be able to repeal a law in its entirety. That will be very rare. Quite often, a certain piece of legislation cannot be repealed in its entirety, but I need to repeal one particular section or amend one particular section. That will require a systematic look at each and every section of each and every statute, and this is much more difficult than repealing the entire statute at one go. And this also involves rationalization and harmonization. Because statutes may have been enacted at different points in time, over a period of time, definitions will have changed. Definitions may not be consistent. And therefore, there will be court cases which leads to further confusion because the jurisprudence will begin to differ. Broadly speaking, I said statutes can be enacted by the union government, they can be enacted by state governments. Sometimes both if they're on the concurrent list. Most statutes on what economists call factor markets, primarily land and labor, they are either in the state list or they're in the concurrent list. If one is striving for growth, if one is striving towards productivity, one needs efficient factor markets. One needs efficient labor markets. One needs efficient land markets. For example, if I'm going to take labor, the earliest law on labor was the Fatal Accidents Act, which was passed in the year 1855. Obviously, since then, notions will have changed. As you probably know from reading the newspapers, so far as union government statutes are concerned on labor, the bulk of them, not all, the bulk of them have now been consolidated under 4 acts. But if I'm talking about land, which is entirely a state subject, that has not yet been done. And in most states, the largest number of statutes pertain to land. And if we have significant delays in the dispute resolution system, many of those cases concern land and the status of land records, the absence of a proper titling system, etc., etc. So a second strand of statutory law reform is rationalization, harmonization, getting rid of old dysfunctional elements. And the underlying message I want to leave with you, that this has still largely been undone in the sense of not being done. There is one other aspect that is a related aspect, you should not forget, lose sight of that, and that is the language used for drafting. Unfortunately, in many statutes, the language used for drafting is A, confusing, not clear. And if the language used for drafting is confusing and not unambiguous and not clear, it leads to conflicts in the case law. And B, there is something called a plain English movement that has been implemented in various countries in the world to make the drafting of the law intelligible to the average citizen. Not just the drafting of the law, to make judgments intelligible to the average citizen. This bit also has largely remained not done. I use the word law. All of us use the word law. But the word law does not always mean the statutory law. There are a whole set of government orders, regulations, circulars, notifications passed using that framework enabling legislation of the statute. Whatever I said about repealing old parts, whatever I said about rationalization and harmonization, whatever I said about language, whatever I said about making them accessible to citizens apply equally well to the administrative law, which is the set of rules, orders, circulars, notifications. For the union government, again, this either has been done or is being done. For state governments across the board, not in one particular sector. In one particular sector, it may have been done because that is part of DIPP's ease of doing business initiative. But I'm talking about across the board. Across the board, the only state I know of where this has been done is Rajasthan. But let me come back to Sunny Deol and the Sunny Deol quote. Because after all, a legal system is credible only if it delivers. Delivers what? Delivers dispute resolution and efficient dispute resolution. Across the globe, whenever citizens have elected governments, the primary responsibility of government has been to ensure defense, external security, internal security, punish the wicked, protect the virtuous, ensure property rights, not only intellectual property rights, there was no intellectual property rights then, and ensure speedy dispute resolution. Primary function of governments anyway. Today, we have a backlog of 35 million cases. Counting cases that are there in judicial forums and quasi-judicial forums. There are cases that have lasted for years and years. There is a Seth versus Basak case in Calcutta High Court for which the last hearing was held in the year 1915. There are several cases that have lasted for more than 40 years, 50 years. When I use the word cases, there are two types of cases. There are civil cases and there are criminal cases. At the aggregate level, about 2/3 of our cases are criminal cases. About 1/3 of our cases are civil cases at the aggregate level. You probably have a vague understanding of the hierarchy of the court system. You have the Supreme Court. Below that, you have the High Court. Below that, you have the lower courts, the subordinate and the district courts. At the aggregate level, about 2/3 of cases are criminal cases. 1/3 civil. If I'm looking at high courts, the concentration, of course, is on the civil side. If I'm looking at lower courts, the concentration is on the criminal side. So therefore, we must make the system credible, deliver justice fast, and there is a very long list of committees, commissions, task forces which have recommended changes to make the dispute resolution system more efficient. Broadly speaking, these are in terms of curbing demand, reducing demand for court cases, use conciliation, use mediation, use arbitration, cut down on unnecessary appeals, etc., etc. A, curb demand. B, move the supply curve, so to speak, to the right, by which I mean more courts, more judges, more benches, so on and so forth. And the third set of reforms is use productivity. Use productivity enhancing tools, have shift systems in courts, use video conferencing, etc., etc. The earliest committee that I know of which made such recommendations was the Rankin Committee, RANKIN, which submitted a recommendation in the year 1924. Unfortunately, most of those recommendations have not been implemented. The Civil Procedure Code was amended in 2001 and 2002, and had it been properly implemented, would have reduced the average duration of a civil dispute to 1.5 years, except land titling issues. Didn't happen because of a court order. So I quickly want to mention that when we are talking about the legal system, quite often we think it is about the executive arm of the government. It isn't. Under the Constitution, there are 3 organs of government. There is the union government or the state government, the executive arm. There is the legislative arm, union government or state government, and there is the judiciary. So if the legal system has to deliver, all 3 have to work together. To give one example, think of IIFT. Are IIFT faculty members entitled to leave once a year? I think they are. So that particular faculty member goes on leave. Does that mean that IIFT shuts down? No, it does not. Individuals go on leave, but as a whole, the organization does not shut down. It does not need to. However, I know of one entity in our structure which continues to have a summer vacation. And I'm not talking about educational institutions. Students may go on leave, but the educational institution, as far as I know, still functions. So there's only one institution which has an institutionalized system of summer vacation, and that is the Supreme Court of the country. The point I'm making before you is, after all, when we look at the question of reforms, the question that arises is, how do reforms take place? Quite often we think that reforms happen because the government decides to introduce reforms. It doesn't work like that. More often than not, governments introduce reforms because there's a groundswell of demand on the part of people wanting that reform. So when the Right to Information Act was passed, there was already that demand, that voice on the part of citizens that there should be the Right to Information Act. Ditto for the Environment Protection Act of 1986. Ditto for the Consumer Protection Act also of 1986. And ask yourselves, as citizens, we will perpetually ask, what is the finance minister doing? How many times will you ask, what is the judiciary doing? Very rarely. I mentioned dispute resolution, I mentioned civil cases, and I mentioned criminal cases. Criminal cases involve the police. So without talking about police reforms, I cannot improve the delivery of criminal justice. And remember, I said 2/3 of cases are criminal cases. On the civil side, I mentioned the Civil Procedure Code. Similarly, on the criminal side, the procedures are determined by the Criminal Procedure Code, the Indian Penal Code, and to some extent the Indian Evidence Act. So obviously these three statutes also need reforms. But there is also the subject matter of police reforms. The first systematic committee to investigate police reforms, and we are talking about pre-independence times, so India was divided into presidencies. And in Bengal presidency, there was a committee on police reforms from the year 1901 to 1902. After that, pre-independence and post-independence, there's been a long list of committees which recommend what those police reforms should be. And when I'm talking about police reforms, do understand, I'm not talking about the Indian Police Service alone. The cutting edge or the blunting edge of the police-citizen interface is the constable, is the ASI. And police reforms are also about those. There was a celebrated judgment by the Supreme Court known as the Prakash Singh case, 1996. As a result of that judgment, the Supreme Court instructed that this is what must be done. And police, except the paramilitary forces, which are slightly different, the special police forces are different. Otherwise, police is a state subject. If you look at the status of implementation of the Prakash Singh judgment by states, you will find that even in the year 2021, most of the recommendations have not been implemented. So again, my question to you is, how many times as citizens do you articulate the need for police reforms? As citizens, are you aware that there are police stations in India which have been ranked as the best police station in the world? So even without the changes in the Prakash Singh judgment, even without changes in the basic law, improvements are possible. So imagine what can possibly happen if all of those changes occur. I'm running out of time, so I've given you a broad canvas of all the different aspects that are there under the umbrella, under the rubric of reforming the legal system. Lawyers and economists look at the concept of law differently. Typically, lawyers and judges will look at law in the following way. You have committed a crime, so therefore you must be punished, and that punishment is in the nature of compensation for what you have done. More appropriate for a civil case. Economists look at the question of law differently. Law is not primarily meant to punish you because of your crime. Of course, that's an objective. But the more important objective of law is to prevent other people from breaking the law in the future. So the deterrent principle is more important. Unfortunately, the legal system is such that it does not deliver that deterrence. I'm about to say something which I must be careful and therefore ascribe it to someone, because you may not know that there is something called the Contempt of Courts Act of 1971. There was a Chief Justice of India, his name was Justice Venkatachalaya. And Justice Venkatachalaya once told me In India, Bibek, everyone who should be inside jail is outside jail. And everyone who's outside jail should be inside jail. And this may seem like an exaggeration, but there is a point to what he said. That, unfortunately, is the state or the misstate of legal reforms in India. At least, as Manoj said in his preliminary remarks, some consciousness is beginning to seep in that this is important. Thank you very much.
Thank you, Vivek. As usual, Vivek is always not just informative but entertaining, and it pulls out the right cases just to make sure that everyone understands the context. And I think one of the points which I at least took, and I hope you have taken, is that economists tend to think that that everything just happens in a vacuum, not realizing that many of the things we feel don't happen because the legal reforms are not taking place. For example, a market is meaningless unless the rules for operation of the market have been defined. Someone's got to do that, and the regulatory mechanism often does it. Russia went through that, remember, they gave up the communist system but had no other system. And there was chaos for about 10, 12 years in Russia after 1903 till they established some system. Anyway, so enjoy it, Vivek, as usual. I always enjoy your lectures. Now we'll give it up to questions to students. They'll appear in a certain order. Minute you have, I presume you'd like to take quite a few questions, answer them together if you want to bunch them. Leave it up to you. I'll ask Panda, Mr. Panda, IT man. Panda, can you line up the students and get them to answer the questions?
Yes, sir.
Is that okay with you, Vivek? You tell
Yeah,
us
that's fine. We have to wind up at 4:30, that's all.
Okay, great. You just say, okay, last question, that's it. Right. Okay, thanks. Yeah, Mr. Panda, go ahead.
Miss Preeti Jain, please switch on your video.
And keep your questions brief and to the point, right? Yeah. Come on, Preeti, no time wasting.
My question is about. Hello, sir. Am I audible?
Yeah. Carry on, please.
Good evening, sir. My name is Preeti Jain, MA Economics 2022. My question is about antitrust laws. Antitrust laws which were made with the objective of providing benefits of competition to consumer. How are they helping in increasing the efficiency in the society if they do?
I will promptly veto the question. What is antitrust law? What do you mean by antitrust law?
Sir, certain laws are made
like what? Like what?
So Competitions Act was made so that the companies do not form a cartel or do not merge, so that consumer have certain options, consumer have certain different products, so that they can choose from. Because if a producer will form cartel, or if they would form monopoly, as we know, in monopoly the surplus is quite less for consumers.
I will answer the question, but the reason I prompted you is one of my intentions was to instill in you the discipline is not to use vague words like antitrust, but to be specific and say the Competition Commission of India. But tell me this, what is wrong with a monopoly? What's wrong with a monopoly?
Sir, from a consumer point of view, we do not have options to choose from. Whatever the monopolist is quoting, the price monopolist is.
Why is there a monopoly? Why is there a monopoly?
Because of certain cost constraints in case of natural monopoly, and some technical things, technological advancements. Someone has discovered the technology which others haven't yet. So the
others will discover that.
So, if I talk about Geo, currently it's having over 50% share of market. But
Okay, let me stop you then. Let me stop you then. But I want you to think about these matters. When I look at a certain market structure, I can analyze it in terms of structure, conduct, or performance. Structure means something like a market share. A market share that is, let us say, 80%. The right question to ask is, why will that market share of 80% continue? It will be whittled down unless there are barriers to entry. Unless there are barriers to entry, that market share will whittle down. So if the market share remains, that is because there are barriers to entry, sometimes erected by government policy. Competition means free entry and exit. That exists in the textbooks. That kind of competition does not exist anywhere in the world. So there may be entry barriers that are erected by the government, or there may be entry barriers of the kind that you mentioned. I've got an invention, I've got a patent. We can have a whole long debate about the utility and the pros and cons of granting temporary monopolies like patents through the Patents Act, but that's a separate issue. The thrust of what I'm saying is that I should not be focusing on structure and market shares, because they will be whittled down. I said structure, conduct, and performance. Performance is what? Performance is about prices. And on prices, I can get into this great debate of predatory intent. How do I ever prove predatory intent ex ante? That's the policy question. Ex ante, can I ever prove predatory content? I will only be able to prove a predatory intent ex post, which is dysfunctional from the point of view of policy, because the damage has already been done. Which is why, as you should know, as students of IIFT, the present anti-dumping agreement does not have any test for predatory intent, which leaves conduct, which can be unfair trade practices and restrictive business practices. Historically, the MRTP Act, which has been replaced by the Competition Commission of India Act, shifts the focus from structure and performance to conduct, as indeed should be the case. But remember, from the point of view of consumers, there are other avenues also. The Consumer Protection Act, for one. Okay, next question.
thank you, sir.
Next, Mr. Avinash Vyas. Please switch on your video.
Good evening, sir. My name is Avinash Vash. I am from MBA batch of 2022. Sir, my question is, actions like the retrospective tax and the annulment of coal mines allocation by the Supreme Court has had very serious negative implications for the Indian economy. So do you believe, can there exist an economic forecast for these kind of decisions? And can that be used to preclude any such decision making?
Either I treat your question as a comment, or I try to distill out a fairly profound observation from your question, whether it was intended or not intended. If I look at any particular court case, whether it is on the civil side or whether it is on the criminal side, the eventual outcome of the case can be predicted within a certain range from the date the case was initiated. So imagine you have a civil suit with your neighbor. The day you started that civil suit, both sides more or less know with a given degree of certainty what the range of outcomes will be. Within that range, you don't know, but that broad range you know. So the question to ask, and here is where the profundity comes in, is if I'm given a certain case, can I, given those parameters, predict in advance, perhaps for modeling purposes, perhaps by using artificial intelligence, what the outcome will be? Is there a certain predictability about court decisions? Can there be a certain predictability about court decisions without uncertainty? And can that predictability be used to make the legal system function more efficiently? There is a slightly different issue, which is the issue of the principles on which the court makes a decision. And remember, a court like the Supreme Court is particularly driven by constitutional issues. So if we have got things like Article 39 in the Constitution, if you've got things like Article 12 in the Constitution, obviously the court will interpret any particular case with those articles in mind. So when trying to look at the mindset of the courts, let us remember that the mindsets of courts are an evolution of circumstances, including the Constitution. So that would be my response. Let us have the last question now.
Thank you, sir.
Mr. Abhishek Malhotra. Abhishek. Unmute yourself. Unmute yourself.
Good afternoon, sir. I'm Abhishek Malhotra, MA Economics student, 2019-21 batch. So my question is, India's tax to GDP ratio has been significantly low, and for years it has struggled to improve it. So according to you, rationalization of GST, income tax changes, how will it affect it?
I will promptly veto the question because it is not pertinent to the topic.
Okay, let's take the next question.
Okay, but Manoj, we are running out of time. Please stick to the subject. Otherwise, you organize a talk on the Indian economy.
Yeah, please. I told these guys to stick to the questions. Next question, quickly, last one.
Next is Anushri Kanariwala.
Good afternoon, sir. I'm Anushri, and my question is that we have seen this trend that whenever a law is about to be passed in our country, there's a lot of tension that goes on, and because of that, the economic activities get disrupted. So, how does the government, does it have a mechanism to take care of the revenue losses that occur because of because of halt in activities in the economy?
I don't understand what you're asking, but since we are running out of time, if you are questioning the existence of parliament and legislative assemblies, and you'd prefer to live in a country where such forms of democracy do not exist, I would suggest that try living in one of those countries and you will immediately want the democracy back. If you are suggesting that democracy sometimes tends to slow down processes, that's desirable, because the decision, whatever is the decision that is being contemplated, needs to be reflected on carefully. I would not like a situation where the 42nd amendment to the Indian Constitution took place, a major amendment, and the entire debate in Parliament lasted for exactly 90 seconds. So obviously there will be the debate. Is it possible to quantify it? Naturally not.
Okay, Vivek.
All right.
I think thanks a lot. I think that one of the concerns the student had was about the cost of interference, but that's the cost of any democracy, which democracy obviously have taken. That's why they remain democracies. Anyway, thanks a lot, Vivek. It's enjoyable hearing you again. And let's hope we'll get you again some other time. Thank you.
Okay.
Bye, Vivek. Okay, thank you.
Thanks a lot, everyone. Thanks a lot for joining.
Here's another meeting coming on from here. Okay, thank you, everyone.